All right, welcome everyone. We'll just give a couple seconds to allow all of our attendees in the waiting room to officially join us. All right, we're starting to see people come in. All right, welcome everyone. Good afternoon. My name is Adam Ketchmarchi. I'm with the Pool and Hot Tub Alliance in their education division. Welcome to today's webinar for the California Pool and Spa Association. Before we get started, I just have a couple of reminders to go through. First is be sure to look out for PHTA and the California Pool and Spa Association, along with our Genesis Education. We'll be at a variety of trade shows and events in the industry this month in March. We'll be at Everything Under the Sun in Florida. We'll be at the Master Pool Guild. We'll also be at the Backyard Pool and Spa Show in Michigan. And then in April, our Genesis Education hits the road with its first ever road show. And I do want to feature really quickly on May 8th to 10th, we will be at the Floridra headquarters in Carlsbad, California. We'll be offering our Genesis C201 construction school for concrete pools. If you do register for that class, the free CBP exam is included. That's at a $250 value. We'll then have our Mastermind Summit coming up in September. You can visit genesis.phta.org to learn all about those upcoming events. Today's webinar is being recorded. It will be available for viewing after today's webinar concludes. Attendees are in a listen-only mode. You can use the chat or the question and answer function at the bottom of your screen to participate in today's webinar. I'll be monitoring the chat and the question and answer during the presentation, and we'll get to as many attendee questions as possible before the end of our hour. All right, so let's get to the main show and let's introduce our speaker for today. Leah Schoen is joining us. Leah is an attorney at the Green Law Group, specializing in business, construction, and insurance law. She brings over a decade of experience in civil surety insurance, having previously served as Associate General Counsel and Bond Counsel for a major surety company. Leah earned her Juris Doctorate from the University of West Los Angeles in 2020, following a master's degree in public administration from California University, Northridge. California State University, Northridge, and a bachelor's of arts from UCLA. She is a published author and speaker. She co-authored a chapter in the Law of Commercial Surety and Miscellaneous Bonds, ABA 3rd edition, and has presented at TIPS, Fidelity and Surety Law Spring Conference. Leah, thank you for joining us today, and it's all yours.
Great. Good evening, everyone. Thank you for the introduction. My name is Leah Schoen. I'm an associate at the Green Law Group. My firm was asked to provide a presentation today on mechanics liens and payment protections, and I'm pleased to be speaking with you all and want to thank the California Pool and Spa Association and the Pool and Hot Tub Alliance for the opportunity to provide you with this presentation. A little bit about my firm, the Green Law Group. Our law practice was originally formed to serve construction professionals with contracts, licensing, and notices. And as our clients and legal needs grew, our law firm expanded to meet that challenge. Today, we offer a full range of services to help small businesses thrive, and our clients rely on us to make sure they are properly organized, their legal documents are in good order, their employees are paid correctly, and their legal liability exposure is limited. Here is a list of all the attorneys at our firm. Scott Green, the founding member. Maz is our business law attorney with extensive experience in corporate law, business litigation, and construction defects. Matthew focuses on our employment law. Simran is our licensed professional engineer and lawyer who handles complex multi-party construction disputes. There's me in the bottom left. Emil is an associate with background in construction law. David Ward has counsel with defense matters, corporate transaction litigation, and arbitration proceedings. And then Bradley Sparks is also a counsel with extensive experience in civil litigation, family, real estate law, contracts, and trademark law. In 1985, Scott also formed Easy Law Construction Notices to help contractors and others in the construction industry secure and collect what they earn. Today, Easy Law provides professionally prepared preliminary notices, mechanics liens, stop payment notices, bond claims, and a collection service for hundreds of clients throughout California. Wouldn't be a legal presentation without a warning disclaimer. So the information contained in this presentation is not legal advice. The law changes constantly with new statutes and court rulings. For legal advice regarding California law and any facts of your particular case or circumstance, it's best to consult with an attorney who would have substantial experience in your area of concern. Okay, moving on to the meat and potatoes of the presentation. So what is a mechanics lien? So under California's Constitution, those contributing to a private work of improvement have rights to a mechanics lien. And that is Section 3. A mechanics lien is a legal claim against a property that has been remodeled or improved, usually filed by contractors, subcontractors, or suppliers that have not been paid. To be able to enforce a mechanics lien, you have to be licensed in California. Unlicensed contractors cannot enforce a mechanics lien or foreclose on a mechanics lien if the work is valued at more than $500. Plus, you run into a no legal right to recover payment under your contract and potential disgorgement claims. Mechanics liens are sort of a special type. They are strictly statutorily compliance required, which means there's timelines that have to be followed, particular procedural stuff that has to be done. And so we'll get into some of that. And of note, a lien, a mechanics lien is going to stay in the county records and on title of a property until an action is taken to remove it. So even although we're going to go over situations where it's no longer enforceable and considered null and void for purposes, it is still going to sit in cloud title unless action is taken to actually remove it from title. Okay, a little bit more about, we'll go ahead and jump to preliminary lien notices. Okay, so what is a preliminary lien notice? This is what the word indicates. It's a pre-lien notice. It's legally required for jobs if it's exceeding $500. Failure to deliver a preliminary notice by a subcontractor could potentially lead to a disciplinary action under the contractor state license law, and it's a violation of Civil Code Section 8216. It used to be called a 20-day preliminary notice, now just called a preliminary notice, but it still serves the same purpose. It's to inform a property owner, prime contractor, or lender that a subcontractor or material supplier has provided or will provide services or materials to an owner or directly contracting party, and therefore has the right to file a lien on that property in case of non-payment. So, the 4 W's. To get a better understanding of preliminary notices, they're intended for anyone who does not have a direct contract with the property owner. They are intended for largely subcontractors, material suppliers, and those who rent equipment. So anyone who performs labor for wages or skills or other necessary services doesn't need to give notice. It is really for a subcontractor and material supplier, or potentially a general contractor if they don't have a direct contract, but normally you'd see with subcontractors and material suppliers. When in doubt about whether you should or should not provide a preliminary notice, it's best and the most prudent to just give notice. So there are, back to the when. Notice needs to be sent within 20 days of starting work. I apologize about that. Needs to be sent within 20 days of starting work. But remember, it's better late than never. So a late notice can still validate a claim for services, but it's only going to validate for the 20 days prior to the mailing of that notice. So it's important that you're calendaring, okay, today is the date of our commencement. We need to send this preliminary lien notice within 20 days. How do you need to send those notices? Well, they can be mailed by express mail services like a Federal Express or UPS. Although what Easy Law does and what we recommend is that you use USPS certified mail and with or without a return receipt, but you want to track it to the location where the work was performed or where the owner of the property resides for purposes of proper notice. And so why do you need them? Well, notice the preliminary notices are your tool to secure and collect what you earn. It's going to open the door to allow you to file that mechanics lien, stop payment notices, or any payment bond claims. So recommendation is if you're a subcontractor or material supplier, you're going to want to make a preliminary lien notice on your list of items that you need to follow through as a standard operating procedure so that you're not leaving any money uncollected and you're preserving all potential avenues of recovery. So what must be included in the preliminary lien notice? You need to have the owner's information. And this is obviously, again, assuming you're a subcontractor or a material supplier, the owner's information of the property, the direct contractor's information, a construction lender, if it's applicable, if there is one, and a description of the site. It has to provide the details about the work that you provided. And if there is a little bit of a deviation or you miss something, it's not necessarily invalid as long as it substantially informs the person who received the benefit of what you provided the notice about the required information. So what happens after you serve the preliminary notice? The owner must provide a copy of a notice of completion by certified mail if they're going to go ahead and record a notice of completion. If a direct contractor is served, then that direct contractor is required to serve the lenders with that preliminary notice. And when a construction lender, owner direct construction contracts, they have to include a lender's preliminary notice information. And I've seen this happen where that construction lender's information is not necessarily provided on the contract itself. So how would you as a subcontractor know to provide notice to the construction lender? It is also the responsibility of the direct contractor to provide that notice. Okay, mechanics lien basics. What sort of is the point? Notice of mechanics lien needs to be served on the property owner or the reputed owner with that document titled as a notice of mechanics lien, and record the notice along with the affidavit with the county recorder where the property is located. If you record it in the wrong county, you're going to have a very difficult time enforcing that mechanics lien in the county in which that property resides. So it's really important that you know which county this property is located in, and it happens where it's sort of like, in between. Best thing is to have a title search run or a property search run, or you use a service provider like Easy Law who will go ahead and check that for you. Failure to properly serve and record is going to render that lien unenforceable. And so there goes a potential avenue for collecting money that's owed to you. The notice informs the property owner that their property could be subject to court-ordered foreclosure sale because there's been unpaid labor, materials, or improvements that have been provided to the property. And the idea of it is that it affects that homeowner's ability to borrow against the property, refinance, or sell until your debt is paid and that lien is released. And California mechanics liens, they only have priority over liens that attach to the real property after the commencement of the work. So, it's not going to get ahead of a bona fide purchase or a purchase resulting money mortgage. But it will be sort of like first in line, first in time. It's the same idea. Go ahead and record, get it done, and then anything thereafter is going to be subject to. We kind of touched on the notice of completion, so I just want to kind of go over the 4 circumstances for private works projects where, the law deems a project as complete. So first one is you have a continuous cessation of labor for 60 days. So that means no works performed for a continuous 60 days. The law says that project is deemed complete. 2, there's a notice of cessation recorded. So that means the owner goes ahead and records a notice of cessation after 30 days. And then after that 30 days, it's considered complete. 3, you have an actual completion of the work of improvement, and that includes any agreed upon modifications or additions, or for purposes of new buildings, new development, the project becomes occupied and used by owner, usually in the form of a certificate of occupancy. Okay, so I put up a mechanics lien timeline as sort of a guide. So what we talked about before was the serving the preliminary notice. Again, if you're a direct contractor, you have a contract with the homeowner, and or the building owner, whatever format it's in. So you don't need to provide preliminary notice. The preliminary notice, and the way that I like to look at it is, it's the person who's receiving the goods at the end of the day may not know all of the contractors and suppliers who participated in getting those goods to them. So you're basically giving them notice of, hey, I'm a material supplier, your contractor's using my materials, and if I'm not paid, I'm going to go ahead and move forward with a foreclosure action on your home. I'm reserving those rights. Subcontractors or suppliers, that's why you have to give within 20 days after you furnish the work or materials or start the work, you have to give notice to the owner, direct contractor, and construction lender, depending on who is participating. Once you've done that, and this is why I went over the completion cessation terms, 90 days after completion or 60 days after the owner records a notice of completion, you need to have your mechanics lien recorded and served. Sooner rather than later is preferred. So if once you've completed that project, my recommendation is you go ahead and move forward with the mechanics lien, and that's assuming that you haven't been paid, right? So you make the request for payment, you wait the time period based off of what your contract states and what's agreed, and then you move forward with your mechanics lien. Don't sit on your hands. If you're a subcontractor or supplier, it's the same 90 days after completion of work or improvement, unless a notice of completion or cessation has been recorded, and then you only have 30 days. And so the or is going to be contingent on the earlier of what's applicable. And the big thing, and what we see all the time, and what I see all the time, is people record their mechanics lien, but then they don't take the last step of filing a civil action to enforce the mechanics lien. And if you don't do that, then it's null and void. You've spent the money to go ahead and maybe serve a preliminary notice, record and serve the mechanics lien, but then you didn't take the last step. So the foreclosure action or civil suit has to be filed within 90 days after recording, or unless there's been an extension by agreement by the property owner to provide an extended period of time to do that. That rarely happens in my experience. So do not, I caution to say, in the cases where, I've run into problems where you have filing issues and it's completely outside of your control, you go ahead and file days before the expiration period and the court doesn't process. And then you have to go in ex parte and demand that it be retroactively dated, because you're going to run into issues because it's now past 90 days. So it's really important, if you're crafting your standard operating procedure, you're going to have that preliminary notice, record and serve mechanics lien, and then you're going to have that mechanics lien foreclosure action on file within 90 days. You can do it earlier, doesn't have to be on the exact 90th day, but no later than 90 days. And there is exceptions. The timeline doesn't apply for design professionals, architects, and engineers. They have sort of their own timeline. So just keep that in mind. So what goes in a mechanics lien? So it's governed by California Civil Code 8416A. And like I said, mechanics liens are statutory. So chances are, if you have a question about what you can or cannot do in a mechanics lien, or what it should or should not say, you can refer to the Civil Code. It needs to have the lien amount that you're claiming is owed after you've deducted all credits and offsets. It needs to have the owner or the reputed owner's name on it. It needs to have a general statement of the kind of work that you furnished or material supplies you provided. The hiring party's name, in the case, obviously, if you're a subcontractor, it's going to be the general contractor. Or if you're a general contractor, it's going to be the owner. A property description. It doesn't have to be a full legal description. It's recommended, not required. You just need to provide something adequate. I say at a minimum, you should have your assessor's parcel number on there, no matter what. The claimant's name and address, which would be you. You're the one claiming. You have, money's owed to you. Proof of service affidavit, and that statutory notice language needs to be in 10-point boldface type. So what amounts can you include in your mechanics lien? The mechanics lien amount has to be limited to the reasonable value of the work that you provided or the price agreed to by the claimant and the person who contracted for the work, minus any payments you've already received. And to be clear, that's payments received by you if you're a subcontractor or supplier, not payments that may have been received by the direct contractor, because that may or may not have actually been received by you. You cannot include attorney's fees in your mechanics lien amount. There is a prejudgment interest of 7% for the lien claimant, and that's protected by the Constitution. So if you use a service like Easy Law, they go ahead and make sure all that information is in there for you. So once, let's say you have the mechanics lien that's been recorded, but you've received all your payment, you can't just leave it, even if it's null and void and no longer enforceable because you didn't go ahead and file a foreclosure action, you still need to go through the process of getting a lien release. So the general principle is that no lien release is binding unless the claimant signs and delivers a waiver and release. And if it's signed by the claimant or their agent, the signed form is effective to release the owner, the construction lender, and the surety, especially in the case of a payment bond. And there are different kinds of waivers and releases. You can find them all on the CSLB website. If you need templates, I did provide sort of the pathway on the presentation, and there's different kinds. They're somewhat self-explanatory: conditional waiver and release on a progress payment. Obviously that's payments being made over time. You don't have the final payment in hand versus one where it's the last and final payment. So if you record a mechanics lien and it's an improper mechanics lien, and let's say because it wasn't commenced within the 90 days, or it doesn't properly identify the owner as the contracting party, or the property owner posts a notice of non-responsibility because you contracted with the tenant and they went ahead and posted that within the 10 days after knowledge that the work was performed, you can run into a situation where someone like me or someone in my office is hired to go ahead and file a petition for removal of that mechanics lien. There is a procedure that has to be followed. So before you can go ahead and just file a petition with the court, you need to send a demand for release of the lien to the owner. And they need to give them at least 10 days before you file a petition. And it needs to be a written notice and demand that the lien be released. So you give them that 10 days, and if they don't release it and show you proof of release, i.e. a release of lien that's been recorded, the attorney would go ahead and be free to file a petition for removal of that mechanics lien. I do want to caution that there is really no limit to recovery of attorney's fees on a petition. So if I or someone in my firm has to go through the exercise of filing that petition, I'm going to ask for all of the attorney's fees that my client incurred to get that lien released. And as long as they're reasonable, the court's going to grant it, just so you know, in my experience. The next thing I want to cover is the Right to Repair Act. I'm not going to spend too much time on it. If there's questions later, I can try to address them, but it's a mandatory procedure that has to be used by homeowners who have construction defect claims against a builder, subcontractor, product manufacturer, design professional before they file a civil suit. There are very specific timeframes within construction defect claims for homes that are sold after January 1 of 2003. This was known as Senate Bill 800 when it passed. The time starts from the date the house is completed, not necessarily the date you close escrow on the property. And it basically limits the time period during which a plaintiff can file a lawsuit after suffering harm, so that there is not just this in perpetuity liability out there that the builder, subcontractor, or other is sort of wondering, am I going to get sued for any sort of defects in any work that was performed? I did put the timelines. There is an acknowledgement period where they, as a contractor, you have 14 days to acknowledge the demand on the claim for defective work. Then there's an inspection. There's an availability of a second inspection. And that's really all protections to limit a plaintiff's ability to recover and sort of, for lack of better, blindside you in regards to what they're pursuing on a defect claim. So one of the methods, and I'm sure everyone's experienced this, is joint payment checks. So if you're getting paid for material supplies or work that was performed, a lot of times homeowners or owners, whoever it is that's contracting, will issue a joint check, which means it's two parties, payable to two parties. And to cash that check, both parties must endorse the check. So you'll see a direct contractor with a material supplier on there, and that is because the payee wants to make sure the material supplier is paid. Essentially to make sure that the subcontractors and material suppliers are paid. So something to keep in mind though, unless there's an actual agreement regarding the allocation of the proceeds of that joint check, the contractor or supplier who endorses it, because you need both, is presumed to have received all sums that are owed to them as of the date the check covers, even if they maybe only received part or none of the amounts owed. So something that you should consider doing if you're a receiver of joint checks is have a written agreement from the owner and general contractor that the endorsement is not an acknowledgement of payment for everything owed. That way you're not waiving any rights that you have to payment, or basically just being stuck held providing supplies or furnishing supplies or work that you ultimately weren't paid for. The other thing I did want to bring up are prompt payment statutes. I don't feel like it's really, I don't see it enough in contracts that I'm reviewing. So I thought it would be of value. I mean, basically, if the parties have agreed in writing that a direct contractor or subcontractor must pay to each subcontractor within a specified time period the amount of a progress payment, which is attributable to the work that that subcontractor performed. Basically that that direct contractor has to pay each subcontractor within that specified period of time. And on receipt of a progress payment, so if a direct contractor receives payment, they have to pay a subcontractor within 7 days, unless there's an agreement otherwise on the time period for the work that was performed. And if that prime contractor or direct contractor fails to pay the subcontractor as required, the statute subjects that direct to a penalty, which is payable to the subcontractor of 2% of the amount due per month for every month that payment is not made. And that also applies to retention payments. In an action for collection of funds wrongfully withheld, the prevailing party will be entitled to also recover their attorney's fees and costs. The only difference is if there's a good faith dispute over all or any portion of the amount that's due, the prime contractor or the subcontractor could withhold no more than 150% of the disputed amount. And again, that's only if there is actually a good faith dispute. And it has to be directly relevant to the specific payment that would be otherwise due. So basically, the courts has stated a contractor can't withhold retention money that was otherwise owed to a subcontractor because of a dispute about extras or change orders, or for other work unrelated to the work under which that they're getting paid for purposes of this payment. It has to be directly related to the work that they performed, nothing ancillary to, which I have seen that come up multiple times where, a contractor will dispute some aspect of the job, not the aspect of the job that my client as a subcontractor is owed the money for. And then my question is, well, did you pay him for the money that he was owed for the work he did perform that's not in dispute? And then most of the time I get an answer of, oh, well, no. Well, what right do you have to withhold those funds? Nothing. You don't have a right to withhold them. You need to pay him for the work that he performed and just withhold for what is potentially disputed. And good faith dispute defenses only excuse the penalty. It's not going to alter an award of attorney's fees to the party that may prevail on a retention claim. The other thing I didn't talk about, but I do want to mention, and something that Easy Law can address also as well if it's something you're interested in, is bonded stop payment notices. And I also really didn't talk about public projects. There is an overlap between a lot of this with private and public projects, but it's best to reach out if you are the type of contractor who does a lot of public works, just to get clarification and make sure there isn't any differences in the timelines or the requirements. And that is the end of my presentation. So Gonna open it up to questions, I think.
All right. And Scott Cohen, who is the past chair of the California Pool and Spa Association, is going to join us for our Q&A session. Leah, thank you for your presentation. And while Scott is joining, I'll remind attendees, please use the question and answer function, use the chat function at the bottom of your screen. We'll get to as many of your questions during the time allotted for today's webinar. Leah, I'll start off by asking you a question. Do you find that a lot of contractors, whether they're in our industry or not in our industry, do you feel that sometimes they're apprehensive to maybe go through this process of a mechanics lien? And, is it apprehension or maybe is the process confusing? What's your experience with that?
I think it's both. There, it comes up a lot where I'll be, if someone will come in and they say, hey, I'm owed X amount of dollars. And my question is, okay, well, did you serve a preliminary lien notice? No, what is that? Well, okay, did you serve a mechanics lien notice? No, what is that? So I think it's people or contractors or suppliers, they don't realize that it's available to them. So I think that, that knowledge, although available, they don't know it's applicable to them or how to navigate it.
Sure.
So I think it's a combination of apprehension, and it is complex. But I think that ultimately is why a lot will use services like an Easy Law, or there's others out there that will help to assist. They're not going to provide you legal counsel, but they're going to help, make sure that the information is properly populated so that you have the best possible chance of recovery when you do move forward to try to execute on those documents and enforce your rights.
Well, and I think that leads into my next question, which is, do you recommend legal counsel in these situations? I know sometimes we look towards online resources, we look towards things like LegalZoom, Easy Law, things, that we can do ourselves without that legal training. But this is a process. This is a legal process that, as you point out, there are deadlines. Do you recommend seeking legal counsel in these situations?
I do, naturally, I do. Um, I would say it's probably good to reach out, and whether it's our office or another office, to just, if you have specific questions or specific, industry type questions, or, work questions that your particular field addresses or whatnot, get some clarification on that, right? If there are limitations on what you can or cannot pursue, or questions about timelines, or things that you're unsure will apply to you, reach out to an attorney, get that clarification. My recommendation would be to, if you're not comfortable with the document preparation, get a service available to you who will go ahead and fulfill that part of it. On the mechanics lien foreclosure action, I have never seen anyone successfully foreclose on a mechanics lien without an attorney. Now, with that being said, I am an attorney, so I'm already participating in that respect. So, but I've never seen anyone else effectively do that otherwise. And that's just because of the complexity of of litigation itself. So my recommendation is, if you do find yourself in a situation where you have a mechanics lien recorded and you're not getting anywhere, and by the way, send the demand letter, right? The legal service is also gonna send a demand with a copy of that mechanics lien to say to that property owner, hey, there's a mechanics lien on your property, and there's a possibility that we will foreclose on that if you do not pay, right? So you want to go ahead and exhaust all those channels. And then if you're not getting anywhere, you got to move forward on the foreclosure action, and you're going to need an attorney to do that for you.
Scott, welcome to the discussion. Go ahead.
Thanks. I'm Scott Cohen from the CPSA,
Hey,
California
Scott,
Pool
how are you?
What's that, Leah?
I'm good. How are you, Scott? It's been a while.
They had me locked in a cage.
Oh.
But hey, I think one of the things that you mentioned is, when you file your mechanics lien, you've got 90 days to perfect that lien by filing a civil suit.
Yes.
And one of the things that I want to caution all pool contractors, all contractors in general about, is once you filed a suit, that a lot of times the other side is just going to countersue you. Their protective response, their defense is going to be, wait a minute, I'm going to find 100 things wrong with the job.
Well, and I'll tell you why, Scott, not to interrupt you, but I'll tell you why. That is because when they file a responsive pleading to your complaint, they need to allege whatever they're going to allege on a cross complaint. So that's why you raise it now or you waive it. So, but yes, you'll often see that as a like retaliatory measure or defense measure.
So what happens is they hire a construction defect expert witness, like myself or some other guy, to come in and write up a report. And now, you're owed $30,000, and they've come up with a list of $100,000 worth of things that need to be fixed. So a mechanics lien really is, I think, a last resort when you're trying to get paid by a homeowner. You want to be very careful to try to negotiate your payment without having to have the threat of a mechanics lien. One of the things that we do at my company is we send a mechanics lien release. So we'll send a conditional lien release. Hey, you owe us $35,000, and this is a conditional lien release. And it's scary. The homeowner's like, wait a minute, lien? Yes, if we don't get paid this money, that's going to be the next step. So as part of our progress payment schedules, we'll often send out a mechanics lien conditional lien release to let the homeowner know, hey, we have a right here to file a lien kind of subtly. We'd like to get paid. And then we'll send you an unconditional lien release as soon as we get this payment. I would encourage guys to do that rather than go straight to filing a mechanics lien. Whatever you can do to settle it. I've seen these things start out and go on for years in the legal battle that you're now spending a lot of money trying to collect on maybe a nominal amount of money. So beware.
Um,
Right. The other thing I do want to point out is, the juice needs to be worth the squeeze, right? And because you are going to incur the legal fees and costs associated with filing that mechanics lien foreclosure action, and you're not going to be able to do much in a limited court. It's going to need to be unlimited. So that threshold amount matters. But yes, I agree. You should exhaust everything else available to you before you go through something that is basically so draconian as a mechanics lien on someone's home.
Right. We have a few attendee questions that have come in. The first one, for federal or state buildings, is the process generally the same for mechanics liens?
Yes, but it's public works, so there is a variation in the timeline. But yes, I mean, it's the same idea, same general process. You just need to be clear on the timelines and the notice.
Excellent. And this question actually comes from the same person. As a subcontractor, we've had contractors who they have great relationships with ask us not to file a preliminary notice. They don't want us to scare off or upset the owner. How would you handle this?
I want to make sure I understand. So it's general contractors who subcontractors ask them not to? I guess I'm unclear.
Yes, the general contractor would have asked the subcontractor not to file a preliminary in this
Okay.
case.
And I'm sorry, so the question was how should we handle this?
Yeah, the contractor basically said to the subcontractor they don't want to scare off or upset the owner. So how should the subcontractor handle this?
Well, I'm sure there's a relationship between that subcontractor and general contractor, but at the same time, if there is a mutually respected relationship, I would think that the general contractor would understand you are relinquishing or waiving your rights to get paid in the event that that direct contractor doesn't pay you or the owner doesn't pay.
Yep.
So
Lien, you have what, 30 days to file that notice?
you have 20 days for the preliminary lien notice from the date
20
that you
days.
commence work. If you, let's say, are going 60 days and you're like, I didn't file the preliminary lien notice or send the preliminary lien notice, you can still send it. It's just only going to cover 20 days back from the date that you sent it.
All right, so if a contractor asks a subcontractor not to file a mechanics lien because it's going to scare, or a lien notice because it's going to scare their clients, then the answer is get paid within 15 days. And so you don't have
Yes.
to file that. And then if you don't get paid in 15 days, then go ahead and file your preliminary notice. So I would tell that contractor, no problem. I don't have to send a prelim notice, but you're going to have to pay us within 14 days or 15 days of the time that we complete the work or invoice for it. Otherwise, we do have to file it. And that's always best to handle as a third-party situation. I have to do it because
Right.
my lawyer, Ms. Schoen, said I had to.
Mm-hmm. Yeah, I mean, and I can tell you, I mean, it's a due process. It's the basics of due process, because I have had homeowners call and say, I paid my contractor all the money that was owed to them. Why am I getting this lien notice? And it's like, well, because the supplier of the materials that were put on your home didn't get paid, and you should have received a preliminary lien notice. And did they or did they not? And if they didn't, they're going to have a decent argument about the fact that they didn't get proper notice as to all parties who potentially had a claim on funds that were owed. So it's a necessary step, not one that I would waive, you know, without much of a fight. But yes, I agree. If you can get paid within a shorter period of time and still maintain that right, absolutely, you should do that.
And I'll just toss out to attendees once again, please feel free to submit your questions in the question and answer function or the chat. Um, we'll get to as many as possible. We do have one submitted right now, and actually, as I read this, Lien and Scott, I'm going to encourage you to open up the chat and take a look at this question. It's a little bit lengthy, so I want to make sure you get the chance to view it in writing as well. Regarding progressive payments with a percentage withheld, person submitting this question says, I work with general contractors where I become the subcontractor. The general contractor has begun withholding 5% from each progressive payment. I will be waiting several months for the general contractor to prepare their portion of the improvements before I continue my work. How long can they legally wait to pay the balance due to me?
That sounds like that falls directly into your statement earlier, which is they have, if they've been paid, the general's been paid, he's got 7 days to pay you.
Yeah, so it's the retention payment, right? They're withholding 5%, that they'll release at the end. But what does your contract say, right? So when are those progressive payments due? And if that progressive payment is due within 7 days, 5 days, 10 days, whatever it is, and they extend it beyond that, then that is the prompt payment statutory penalty that I was going over before, where it attaches the 2% on the recovery.
In a previous webinar that we did with the Contractor State License Board, one of the things that she said was really important is just have your progress payments tied to some form of completion of a phase. So we are completed with the pool shell, right? So, or completed with the shotcrete portion of the pool shell. At that point, you're entitled to get paid in full up to that point. And any general contractor is going to have to pay that too, or it's delinquent. I wouldn't accept that. And of course, your contract, you should have a contract with your general contractor, and any sub, and pool contractors should have signed contracts with their subcontractors as well, showing that they're insured, but also addressing when payment should be anticipated. Is it a net 30, net 15, due on delivery, whatever the arrangement is, it should be mutually agreeable and then followed.
And I can't tell you how many times I've run into situations where a general contractor says, I don't have contracts with my subcontractors. And it's like, okay, well, subcontractor, how are you going to enforce any of the terms of your contract? When do you get paid? What is expected of you? What's the scope of work? What is the recovery? What is there an attorney fee recovery? Are you stuck in with arbitration? Right? All of those things. And I understand it could be a pain to have one every single time if you use the same people. My recommendation is to have a master agreement and then just do addendums for specific projects. And it's still, as long as that main master agreement is identified, it's integrated. And so that way you don't have to do it every single time. It's just, you can just do a exhibit that addresses that specific project that you're having them work on.
So one of the things I want to ask you, Leah, and this goes specifically to the joint checks agreements that you discussed. I heard you say in your explanation that there should be written agreements between the parties before that check is cashed. what form of documentation do you recommend for that? Because I think when people hear they should document or there should be an agreement in place, what is something to that would eventually hold up in court?
You should have that language in your subcontract agreement with your general contractor. The other thing I would caution is there's a lot of subcontractors who by default end up having to accept the terms of the GC agreement with the owner. And there's a lot of limitations and exclusions in regards to your rights and abilities. So you should ask for a main copy of that general contractor and owner or master agreement, so you know what those obligations are and that it doesn't contradict anything that's in the subcontractor agreement. But that best language is going to be in this, everything that you want or should, are expecting, or whatever you guys have decided should be memorialized in that subcontract agreement, so that you're not looking for extrinsic documentation that may or may not even be available to come in as evidence in support of your claim.
It's the homeowner that has that legal right to write that two-party check if they want to, right?
Yes.
Is there anybody know of a bank that'll cash a two-party check anymore?
I see it a lot for large construction projects. Not so much on the smaller side, but massive, building, especially public works. I'll see a lot of two-party checks, which is always sort of, okay, well, which one is depositing it? And I've seen where the direct contractor is like, well, all the money went to pay the supplier and I actually didn't get any money. And then there's a dispute about, well, we paid you. No, you didn't. You paid my supplier. So it's not, it's not ideal. It benefits the homeowner, right? Because at a minimum, the material supplier is going to get paid. Otherwise, they're not going to provide supplies to that contractor anymore. But it's not really beneficial for the subcontractor, because chances are you're going to get shortchanged.
Do you feel that both contractors and subcontractors should have their agreements reviewed by legal counsel on, a routine basis? Because that's something that I think a lot of people get in the habit of using the same agreements over and over again, and there may not be the right protections in place.
Or they just borrow one from someone else, or they look on Google and use that one. Yes, it's recommended that you have legal counsel review your contracts, because it may or may not actually serve you, right? If you're having to run into a situation where you have to enforce on a breach of contract claim. The other recommendation is, and in the other webinar we did previously, I think it was the new 2024 laws or whatnot, when we did, I talked about home improvement contracts. And home improvement contracts also, you should have those reviewed, because they are very specific in regards to the information that needs to be in there, including mechanics lien language, dual arbitration signatures, etc. You don't want to run into a situation where you now have a citation because you didn't use an HIC, a home improvement contract that's been compliant, and are now violating the Business and Professions Code. So you should also have someone's, a lawyer take a look at that as well.
That came up recently in an expert case that I was working on, where the contractor was missing several items from statute 7159, which is the home improvement contract requirements. And because he was missing what they considered to be a substantial amount of items missing from that contract, it became unenforceable. And the judge actually told the contractor that it was disgorged and he was going to have to pay the money back. So we hear the threat of disgorgement regularly, but we don't ever hear it really happening. And it really happens in California. It can, if your contract's not clear, especially when it involves a swimming pool.
And or your license is lapsed for whatever reason, and you don't have it retroactively reinstated, so that there isn't a lapse, and then you contract within that time period, you run the risk of disgorgement, which means all the money that's been paid to you, you potentially are going to have to pay them back for, which is very, very harsh.
The same thing goes for working outside your classification. If you're a C53 and you're a pool contractor in California, and you do the front driveway, well, the front driveway is not incidental to the work that you're doing in the backyard. And if the homeowner chooses not to pay you, They don't have to.
Yeah, don't want to be in that situation. And on home improvement contracts, I will just say, you know, you can reach out to us. I review them all the time. It's literally like a checklist, right? Making sure that all aspects of what the business profession code says needs to be in there is in there. And as long as you follow that, you should be good to go and not run into that problem.
You know, Leah, I often wonder, there were a few times in your presentation that you brought up the California Constitution or California specific law. And I think some of the dangers we run into in today's very internet savvy world is laws differ by states. If you're referencing very specific things in California law, if you were using language that is ambiguous in California, but maybe language accepted in another state, that doesn't help your case.
Mm-hmm. Right. There's precedent. There's case law that's persuasive but not binding, right? You could be citing the wrong statute, or an old prior dated one, or one that has, you know, a case that has since been overturned, right, or appealed. So this is why, going back to the question, it's best to just hire an attorney to pursue those for you, especially if you have an attorney fee recovery provision. So then there's at least a strong possibility of you being able to recover those fees if you're the prevailing party.
Mhm. And Scott, I'm interested on your perspective on this. As someone who has been a contractor and has likely had to file mechanics liens, do you ever hesitate in this? Do you ever, second guess this? I think sometimes when people are new to this, I asked this question to Lee earlier, sometimes people might be hesitant to do this. What's your experience and what would you recommend to your professional colleagues?
So I've been building for 35 years in California, and there's been three instances that we've had to file mechanics liens. So it's very rare. We always try to negotiate ahead of time to get that so it doesn't become a blown up thing. Now on two of those, it was maybe 10 years later that we got a call from, a panicked escrow officer that, hey, we have this lien and what do? We got to pay this. The title insurance company discovers it. And, then we're finally getting paid and some interest on that as well. But it can be a long time before that happens. We do have one right now that we had to file, and it is in that property's in escrow and we should be able to get paid in the next couple of weeks. But again, very cautious to file mechanics lien because it doesn't mean anything until you perfect it. And you have to perfect it within, did you say 90 days?
90 days from the date
90
of
days.
reporting. Yeah.
So that means you have to file a lawsuit against your client within 90 days to perfect that lien. And Leah, is there an actual hearing where a judge determines whether the lien is appropriate or not?
Yeah, so it runs a similar path as a civil action dispute. So there will be a hearing at the end. I'm gonna caution it could take up to 18 months potentially. So be prepared for that. But yes, there
Up
will
to
be.
18 months to get your
It
mechanics lien
could.
perfected?
No, not perfected, to get to the end where you're actually now have an order from a judge to go ahead and move forward with the foreclosure aspect of it, right? So a judgment has been entered, ruled in your favor. You are entitled to go ahead and get your money out of the sale of the home, and then you walk in with the order to go ahead and move on a foreclosure. So yes, it is going to follow a civil action process, where they're going to dispute whether the money's owed or whether it's not. And so there will be that process that'll go on. But it's interesting on your point. When did you say on the mechanics lane that you were just talking about, was that one that wasn't enforced and just recorded? Were
I'm
you
sorry, say that. Can you ask that again?
Yeah, so you had mentioned that there was a mechanics lien. It sounds like a mechanics lien sitting on a property for 10 so years, right? And then the escrow officer called you about getting it released. That was an instance where it was just a mechanics lien recording, not an actual judgment from a civil action, right?
I guess not. We thought we did what we had to do.
Mm-hmm.
But it definitely came up as in something in the records, and that's happened twice. Both times it was about 8 to 10 years following the time that we sent in the paperwork. It's kind of like finding money in an old jacket. You get dressed, you reach
Yeah,
into your pocket and you go, oh, there's money I forgot I had. It's
it's
great,
the
found
same,
money.
yeah, it's the same thing for judgments, although you have to renew those every 10 years for them to be viable. The situation that you're discussing, I've seen that on the, previous life on the surety side. When I was in-house counsel, we'd run into that situation. And it's really not about the escrow, but more about being unable to get title insurance.
Mhm.
Right? Because you don't have clean title, because there is now a lien that is still sitting and clouding title on the property. So basically they're paying you to get you to agree to release that, so you're no longer clouding title. The other issue you can run into is if you leave it for too long and you've already been paid. So you've been paid, you just let it sit. It's not enforceable. You can't file a foreclosure action now 10 plus years later. But you could run into a possible case of slander of title because you're improperly clouding title. So I'm sure that doesn't help ease anybody's anxiety, but just know that it exists and it's out there, and we see it.
We just have a few minutes left. I know we've had a number of questions come in, so let's see what we can get to. First one, if a mechanic's lien has been filed without a preliminary notice, can the subcontractor who filed the mechanic's lien receive a disciplinary notice from the CSLB?
Yes, you can, but that has to be initiated by someone, right? So likely the individual who you have reported a mechanic's lien without properly serving a preliminary lien notice, if they're relatively sophisticated or they've reached out to somebody who's knowledgeable in this area, they're going to say, you should file a complaint with the CSLB against their license because they have improperly filed a mechanic's lien without going through the process of a preliminary lien. So it's not like you're gonna automatically get tagged the second you do it, but if there is a complaint and there's an investigation opened, that is a risk that you may.
I will tell you that, I worked for 22 years as an industry expert for the Contractor State License Board, and they are a division of consumer affairs. And so they work hard for homeowners to defend and protect homeowners. They are very hesitant to get involved in disputes between contractors. And so I would be very surprised if they stepped in and did anything about reprimanding or fining a subcontractor that didn't submit his paperwork on time.
Well,
They certainly could, but it's unlikely.
it sounds like the question was asking about recording if a subcontractor records mechanic's lien without going through the preliminary lien notice process, right? And so that means that mechanic's lien has now been recorded against the property of a homeowner, most
Oh,
likely.
of a homeowner.
Right. And then you are going to get the CSLB going to step in if that homeowner complains and files a complaint. But I agree, they don't really care about contractor disputes against other contractors. The only time they do seem to have interest is if a material supplier isn't paid by a contractor. Then they seem to have no issue coming down on a violation.
This will be the final question we get to tonight. If a general contractor hires a subcontractor to work a specific part of a job, but they do not complete the work as expected, and the general withholds payment from the subcontractor until it is completed properly, but they spend months going back and forth as to whether they are entitled to get paid or not, is the subcontractor allowed to file a mechanic's lien?
So in this scenario, is the general contractor's been paid for the work, but the general contractor's withholding payment to the subcontractor?
That's what it sounds like, yes.
I mean, my understanding, and maybe there also could be things at play here that I'm not entirely clear about, but if you are not paid for the work that you performed, you are free to go ahead and serve your preliminary lien notice and record your mechanic's lien. Because you have no control over the fact that the general contractor got paid and is withholding funds to you, right? And now yet you've relinquished any right that you have to go ahead and move forward with that in the hopes that they're going to pay you, right?
Absolutely. Well, I'd like to thank you, Leah, for joining us today and conducting this presentation. Scott, thank you for all your work and helping to set this up and put together our agenda for today. And most importantly, thank you to those attendees who took time out of your day to join us and learn this important information. Just a couple reminders before we go. just keep an eye, genesis.phta.org. We have a lot of upcoming education, both across the nation, everything under the sun in Florida, the Master Pool Guild, as well as the Backyard Pool and Spa Show just this month in March. We have education going on all around the country. And then the Genesis Roadshow kicks off in April. We'll be at the Floridra headquarters May 8th through the 10th, holding Genesis C201. And if you register for that course, your free CBP exam is included. That's a savings of $250. We do have weekly PHTA webinars that take place at noon on Wednesdays. That's noon Eastern Time, 9 a.m. Pacific Time. You can visit phta.org, check out our schedule of events for all upcoming webinars and both virtual and in-person education. Our next webinar will be Wednesday, March 12th at 9 a.m. And that is 10 Pitfalls of Leadership, and Paul Blake will be joining us for that. Leah, thank you so much. Scott, again, thank you to you. Thank you for all watching. We hope everyone has a great and safe evening. We'll see you at our next webinar.
Thank
Thanks,
you,
Adam. Good
everyone.
night.
Thanks, everyone.